Welcome to today's program titled Emerging Trends in ERISA Litigation, Midyear Update 2023. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for the informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Ada Dolph. Ada, please go ahead.
Thank you, Donna. So welcome to our webinar, providing a mid-year update on ERISA litigation. We have a lot to talk about today. I'm Ada Dolph, a partner in Seyfarth Shaw's Chicago office and a member of our ERISA litigation practice group. I'm joined by my two colleagues, Jules Levinson, a senior counsel in our Chicago office and also a member of our practice group, as well as Ryan Ticker, an associate in our Los Angeles Century City location. Next slide, please. Okay, so in terms of topics we're going to cover today, we'll talk about the ever-present 401k fee litigation, which continues a similar pace to the filings of the last couple of years. We'll talk about one of the newer types of claims, cross-selling claims, that has been decided, as well as some developments in the prohibited transaction area, which are really important. An update on cash balance litigation, Article 3 standing after the Supreme Court's decision in Thole and how that's playing out, as well as developments regarding arbitration and the emergence of jury trials. And we'll end with an update on health and welfare litigation, including a cautionary that we think that this area will grow significantly from a fee litigation perspective over the next couple of years. So with that, next slide, please. Next slide. Okay, so the main case in the fee litigation context that's been working its way through the courts is the Supreme Court's decision in Hughes versus Northwest University. This case was decided in 2022. Fundamentally, it's about two participants in 403B defined contribution plans who make the same types of claims we see everywhere, excessive record-keeping fees and high investment option fees. In this case, it grew up through the Seventh Circuit, so the district court granted a motion to dismiss. The Seventh Circuit upheld it, and both the district court and the Seventh Circuit relied on a line of law that essentially said if you offer a diverse menu and you've offered the types of investment options that are sought, you have some basis for defeating a complaint at a motion to dismiss stage. Next slide, please. The Supreme Court felt otherwise, and so that's what we're seeing play out through the courts. It reversed and went back down to the Seventh Circuit, and now we're seeing the results of that, as well as how courts across the country are treating the Supreme Court decision. So the pieces of the Supreme Court decision that the Seventh Circuit really focused on were the use of the terms context specific and then plausibility, not actuality. And that second one is sort of my term of art to shorthand the ruling from the Supreme Court. And essentially, the Supreme Court told the Seventh Circuit that the pleading standard it had used to decide the motion to dismiss was not appropriate. It basically placed too much reliance on a participant's choices and said the Supreme Court said that doesn't insulate you from fiduciary liability. Each menu option carries with it its own fiduciary liability. The plaintiffs also, the defendants also talked about that Hughes meant the Dudenhofer standard should be applied, and the Seventh Circuit rejected that holding. What that means is the Dudenhofer standard was a pretty high pleading burden for an employee stock drop case, and the defendants argued that it should apply here. The court said, no, we don't have to go that far, or plaintiffs don't have to go that far. They just have to show plausibility, not that this other option plaintiffs are urging was actually available. So the pleading standard the Seventh Circuit came down with is the pleading standard is plausibly alleging actions by a fiduciary that were not within the range of reasonable actions. Next slide, please. The court also talked about the share class claims. As I said, that it let survive this motion to dismiss. Here again, we see the context and the plausibility, not actuality, playing out. The plaintiffs did not need to show, the Seventh Circuit held, that the comparator share class was actually available. They just needed to show it was plausibly available. And the Seventh Circuit held that it felt this is consistent with post-Hughes rulings in other circuits. One thing of note, at least from a Seventh Circuit perspective, again, in the initial Seventh Circuit decision, they relied upon a line of precedent that provided that if you offer a diverse menu of options, there was some protection in that. And that comes from Loomis versus Exelon and Hecker versus Deere, cases you might have heard about in the past. The Seventh Circuit expressly found that those lines of cases were abrogated, except for a few pieces. So here's what survives in the Seventh Circuit. That paying record keeping fees with revenue sharing is not a per se breach of fiduciary duty. So that's good news. We certainly continue to have plaintiffs that are making that argument. That fiduciaries are not required to scour the market to find the cheapest fund. And third, that they can offer a wide variety of investment options without breaching their fiduciary duty. There were some allegations that there were too many or too few investment options in this case as well. And essentially the court said, this is how it characterizes Supreme Court's holding, that ERISA does not allow the soundness of investments A, B, and C to excuse the unsoundness of investments D, E, and F. So that's where we are at in the Seventh Circuit. And we've also seen other courts following suit. Next slide, please. In the Matney versus Barrick Gold decision, which was just decided at the beginning of September, again, the court there actually affirmed dismissal of fiduciary breach claims based on record keeping costs and costs of the investments. There, the court focused on a term that I think we'll hear a lot about and will show up in a lot of these cases. That is that the plaintiffs need to use a, quote, meaningful benchmark when they are making a comparison or urging that fiduciaries should have done something different. And the court talked about there a problem that we have in this litigation, which is the plaintiffs go to the forms 5500, divide out the reported expenses by the number of participants. They come up with a number and they allege that that's the amount that's paid for fees. Very, very often that is incorrect because it doesn't take into account rebates on fees, share classes, what's contained in that reporting and that sort of thing. So the court here said, we need a meaningful benchmark to compare it to. It also held that the lack of an RFP by itself does not state a claim for imprudence. And it focused here on information that was presented that showed the record keeping costs had lowered multiple years after multiple years. So the court said, look, we see this active fiduciary reviewing this and concluding that, or working with the record keeper rather, to lower those fees. What's unique about this case, and I guess I would point it out for future litigation, the court there considered quite a few documents as incorporated into the complaint. The documents that incorporated included plan documents, even a service provider agreement, it appears from the opinion. And the court said, you're alleging in the complaint that the investment options, sorry, I was distracted by a note on the screen there. You're saying in here that the investment options, the R5 and the R6 investment class, are too expensive, and it quotes some prices. And the defendants in that case put in front of the judge plan documents that showed that those allegations in the complaint were false, that it showed very clearly that the participants, while charged that initial amount, received a rebate of 0.15 basis points, which certainly impacts the overall price. So this court was unique, I would say, in that it really went into whether this was a meaningful comparison, whether the allegations were supported or not. Next slide, please. On this slide, we just have an assortment of cases and the way they're coming out, which is a variety of different ways. Next slide, please. I think the takeaway is that, as we have sort of been talking about for years now, 401k plan fee litigation is not going away anytime soon. The Supreme Court's Hughes decision was sort of as clear as mud and said everybody needs to look at context, but wait, there might be times where a fiduciary has to consider multiple different factors, and that could inform their decision. So make sure you're taking that into account when you analyze a complaint. What this means is at the motion to dismiss stage, complaints are getting more scrutiny. And we anticipate, as has been going, that it will be more difficult to dismiss these cases early on in a motion to dismiss. But certainly the complaints are going to be more detailed in order to survive motions to dismiss. The one side note I want to make here, talking about ERISA class action and litigation trends, just recently we've started to see a pickup in ERISA class actions challenging the plan's use of forfeiture funds, that is, funds that are forfeited back to the plan. There's some allegations that the plan sponsors use the forfeiture account impermissibly to offset company expenses. This type of litigation comes down to your plan document. So this is my pointer for you guys to go look at your plan documents and make sure that it accounts for some discretion on the fiduciary's behalf or allows for the treatment that you are giving to forfeitures.
And one other point to add on to what Ada was saying for scrutiny of complaints post-use is that as we've seen over the years as this litigation has developed, the quality of complaints and the specificity of the allegations can vary widely between plaintiffs' firms, and the quality of those complaints is probably going to start playing a larger role in the viability of motions to dismiss. It's not obviously going to be the be-all and end-all because the substance of the allegations obviously matters, but the ability of the plaintiffs' firms to actually allege particular facts that might make it difficult for a court to overlook those facts at a motion to dismiss stage could start playing a pretty big role in success on motions to dismiss. And we've seen over the years that, frankly, different plaintiffs' firms have different quality of complaints. Some complaints are a lot more detailed. Others look like they've been simply copied and pasted from other firms that have a little bit more experience in this space. So that'll be something else to look out for as litigation develops. Ada, I think you're muted. Ada, I think you're on mute.
Oh, go right ahead, Jules. I was just turning it over to you to talk about the cross-selling claims.
All right, thanks, Ada. So next slide, please. Okay, this slide is good. One sort of new variety of claims that we've seen in the 401k litigation space is the concept of attacking plan fiduciaries for cross-selling or trying to get additional business beyond what they already have. One case that's come up on this recently is REITs v. Aon Hewitt. You see the citation there on the slide deck. It was, as a general rule, a pretty standard issue claim of breach of fiduciary duties of prudence and loyalty. And one sort of twist on the loyalty claim was that the plaintiffs claimed that the investment advisor improperly tried to get additional business while it was investment advisor. So, as I'm sure everyone is aware, ERISA requires that plan fiduciaries act solely in the best interests of plan participants. So fiduciaries can't be motivated by their own self-interest in deciding what they're doing for the plan or in carrying out whatever duties they've been retained by the plan to conduct. The caveat here is that there's a long line of authority, including from the Supreme Court, that fiduciary duties are not, fiduciary status is not an all or nothing proposition. Just because an entity or a person has a fiduciary duty to a plan in certain circumstances doesn't mean that they owe that fiduciary duty to the plan in every interaction with the plan. And if you think about it, it makes sense. Plan sponsor has certain fiduciary duties to the plan, but that same sponsor could end the plan entirely if it chose, and that's not a fiduciary action. So the cases have drawn a line between when a fiduciary is acting in the context of its fiduciary status, in that case it owes a duty to the plan and the participants, versus when a fiduciary is not acting within the scope of its fiduciary status, in which case the entity is not classified as a fiduciary with respect to owing duties to the plan or participants. So what happened here is that there was the plan hired an investment advisor, and the investment advisor's scope of duties was to provide advice about investments. What sort of investments would be good for the plan, keeping an eye on the market generally, that sort of things. But while the advisor was serving in that role, they were also trying to get the plan to hire them to do more services, to, for example, serve as what's called a delegated fiduciary, to actually make investment decisions for the plan, which they were ultimately hired to do. One of the claims in REITs was that by trying to cross-sell and get additional business from the plan, the investment advisor breached a duty of loyalty because it was acting to further its own interest as opposed to the interest of the plan. And both the district court after a bench trial and the Court of Appeals for the Fourth Circuit rejected that holding. The Court of Appeals, the key point of the analysis was that the investment advisor was only a fiduciary when it was providing investment advice. And cross-selling other services wasn't investment advice, so that wasn't a fiduciary action. The court also rejected other loyalty claims regarding recommendations of which investments to use, which were fiduciary, because the investment advisor wasn't putting its own interest first. But with respect to the cross-selling, it would seem that there was a potential problem if that had been a fiduciary action. The majority held that it wasn't. The dissent was not as convinced. And this is something, next slide, please. This is something that we expect to develop, and we expect plaintiffs' firms to potentially to latch onto. Even though the Fourth Circuit affirmed the district court here, the boundaries between what is fiduciary conduct and what isn't fiduciary conduct aren't always clear. So, for example, if an investment advisor were giving investment advice that also benefited the advisor, that could potentially give rise to a claim. Whereas here, the allegations were that the advisor was just trying to get other business unrelated to investment advice, and the Court of Appeals held that that was on the good side of the line. It was not fiduciary. And two other points to keep in mind here is, one, there was a dissent. So I would certainly urge anyone who's interested in cross-selling to tread carefully. It's not like there is a sort of consensus of court opinions on cross-selling. And it would not be surprising if a court, a district court, a court of appeals at some point were to potentially take the view of the dissent in Reitz. And the other point here is that even though the defendant won here, it required bench trial. There wasn't a motion, they didn't win on a motion to dismiss, they didn't win on summary judgment. So from a practical perspective, there's a significant cost to litigating all the way through trial. So even though the defendants were vindicated here, that is something to keep in mind when considering cross-selling. Next slide, please. And sort of the, I suppose, flip side of the cross-selling piece is that any transaction with an entity that's already providing services to the plan has the potential to be a prohibited transaction under ERISA. ERISA Section 406, 29 USC 1106, for those of you keeping score at home, prohibits a wide range of transactions in pretty broad language. Fiduciaries can't cause the plan to furnish, to enter transactions that are sale or exchange or leasing of property between a plan and party in interest, or the part that's relevant here is the furnishing of goods or services or facilities between a plan and a party in interest. And the problem that comes up is that the prohibited transaction statute is written very, very broadly. And the definition of party in interest is very, very broad. Any entity that provides any services to a plan is a party in interest. So one, if you take that to its logical extreme, if you can't enter into a contract for services with any entity that provides services to a plan, well, you might come to the conclusion that renewing a contract with an existing service provider is a transaction prohibited by ERISA. Even though obviously contracts have sort of definite lengths, and plaintiffs have brought claims asserting that contracts need to be revisited constantly. If you read 1106A, 1106A1C literally, anytime you renew a contract with an existing service provider, that's a potential prohibited transaction. And in Bugelski versus AT&T, that is exactly what the Ninth Circuit said. The plan at issue had had the same record keeper since 2005, and in between 2012 and 2014, there were some changes to the agreement with the plan and the record keeper to allow the record keeper to receive compensation from additional services that other vendors provided. And the Court of Appeals looked at that and said, you know, that's a prohibited transaction under Section 1106A1C because the record keeper already provided services to the plan. So any new contract that they entered into was a contract between the plan and a party in interest, which, if you think about it, means that potentially there is a claim against every single plan and every single service provider that renews a contract. ERISA does provide exemptions from the prohibited, the broad prohibited transaction language, but there's a couple issues with that. One, they require, one of the main exemptions requires reasonable compensation, and the Ninth Circuit held that that requires looking at all of the compensation that the record keeper or service provider receives, not just what the service provider receives from the plan. The upshot of that is there are a lot of details that have to be scrubbed out and might not be easily resolved at the motion to dismiss stage, and possibly even not the summary judgment stage. Next slide, please. Sort of another potentially bigger issue is that courts have generally treated the prohibited transaction exemptions under Section 1108 as affirmative defenses, which means that they're very, very hard to assert at the motion to dismiss stage. And that means that, and taken to its logical extreme, we have a potential situation where a plaintiff could assert at least post motion to dismiss viable claim anytime any plan renews any contract with an existing service provider. It's in some tension with the Ninth Circuit's decision in Santameno versus Transamerica 5 years ago, which drew the fiduciary non-fiduciary distinction when a service provider is negotiating a contract and a plan is negotiating a contract. But to the extent that any service provider is a party in interest, there's a potentially very high ability to extract fees and possibly extract settlements out of plans just by saying that they renewed a contract. And there is currently a petition for rehearing pending, and I think Ada has some thoughts on that.
Yes, and to echo what Jules was saying, I think the biggest issue with this decision is that it continues the slide toward making it very, very difficult for a defendant to get rid of one of these cases early on in the case without having to go through what is always in these cases a battle of experts and very, very expensive discovery, which the plaintiff's counsel and the plaintiff's bar is well aware of and utilizes in terms of discussing settlement rather than proceeding on a claim that has survived a motion to dismiss. The petition for rehearing en banc is currently pending, and Seyfarth was able to participate in that and filed an amicus brief on behalf of several associations that are looking at the impacts of this holding. So we are hoping for that petition to be granted. With that, we can go over to Ryan.
All right, next slide, please. Thanks, Ada. I'll be talking a little bit about a recent case involving cash balance litigation. Cash balance plans are a type of defined benefit plan that operate a little differently than other types of retirement plans like 401k profit sharing plans or traditional defined benefit plans. McCutcheon versus Colgate-Palmolive Company is a Second Circuit case that was decided on March 13, 2023. The plaintiff, Rebecca McCutcheon, brought a putative class action under ERISA, alleging that the plan sponsor wrongfully calculated and underpaid accrued retirement benefits. The Second Circuit ruled in favor of retirees and held as a matter of first impression that the plan sponsor's use of a pre-retirement mortality discount when calculating present value of lump sum distributions violated ERISA. McCutcheon was a participant in the Colgate-Palmolive's Employee Retirement Income Plan, which was a defined benefit pension plan that was then converted from a final average pay plan to a cash balance plan back in 1989. After her retirement, the plan was amended retroactively with respect to paying and calculating accrued benefits through payment of residual annuities. McCutcheon alleged that the plan sponsor wrongfully calculated and underpaid and accrued retirement benefits in the form of residual annuities for participants who took their benefits as a lump sum rather than as an annuity. On appeal, the court held that the plan sponsor's calculation of residual annuities by subtracting the value of the participant's actual lump sum payment converted into a hypothetical annuity payable at age 65 from a personal retirement account annuity rather than from the greater of the personal retirement account annuity or a grandfather annuity resulted in an impermissible forfeiture of benefits. The court held further that in calculating residual annuities, the plan sponsor was required to use the Pension Benefit Guaranty Corporation or PBGC interest rate as a discount rate for valuing a participant's actual lump sum payment as a hypothetical annuity. And in calculating residual annuities, the court held that the plan sponsor was required to use the 20-year Treasury bill interest rate plus 1% when calculating the value of a PRA annuity. And finally, as a matter of first impression, the plan sponsor's use of a pre-retirement mortality discount when calculating present value of lump sum distributions for purposes of calculating residual annuities violated ERISA and the Internal Revenue Code's actuarial equivalence rules because under the plan, a participant's death benefit was equal to his or her pension benefit. All right, next slide, please. And I'll flip it back to Ada to talk a little bit about Article 3 standing again.
Thanks, Ryan. So this Article 3 standing section is talking about how the Supreme Court decision, Thole versus U.S. Bank, which was issued in 2020, has impacted fee litigation in particular and class certification discussions in the context of ERISA class actions. So when Thole first came out, it held that the plaintiff in that case did not have Article 3 standing to bring the claim because it involved a defined benefit plan where the benefit paid to that participant would stay the same regardless of the actions of the fiduciaries in that case. And so the court concluded there was no harm to that participant, no standing, and that case goes away. From a defense perspective, we were excited to see that because we often have named plaintiffs who have invested in maybe one of the investment options that are challenging, but it's very atypical to find a named plaintiff that has some skin in the game, I guess I should say, with respect to all of the allegations in the complaint. So what the defense bar has done is taken a look at this and argued in the context of class certification that the named plaintiff, unless they're personally involved, vested, harmed, they should not be representing the class. So the circuits have really split on this issue, and we'll talk here. So Chavez goes through both types of ways of analyzing this issue and concludes in its case that the named plaintiff passed both bars, but it is interesting to analyze the different ways that the courts have looked at it. So the Fifth Circuit in this Chavez case says, okay, it looks like there are two ways that the courts have analyzed standing. We'll call one the class certification approach and the other one the standing approach. The first, the class certification approach, starts with the named plaintiff themselves, looks at their standing. Does this person have any standing to bring a case in federal court? If yes, then the court goes on to address the class certification in the class and deals with the particularities of what the named plaintiff is invested in and draws connections between the claims of the named plaintiff and the claims of the class at that point, but it treats those as class certification issues, not constitutional standing issues. The second approach, the standing approach, is one that says, okay, named plaintiff, you need to have standing in every area that you plan to bring a claim. And then it goes on, once you pass that burden, then you go on to analyzing the class and how it matches up with the named plaintiff's claims. So it's sort of a nuanced difference there. What I will say in this case, the Chavez case, the Fifth Circuit, went through both approaches. With respect to the standing approach, it looked at the named plaintiff and said, okay, you've got an injury here, and it is, sufficiently similar to claims in the class. And so that's sort of how it made that jump from the named plaintiff not being invested in every investment option or harmed in all the ways alleged in the complaint to being able to represent a class with all of those claims in it. Next slide, please. So these two slides talk about the splits, and it's important, I think, to know what circuit you're in and understand that this is an area we could see some Supreme Court activity on if we get a petition up there, because of the differences in the analysis. And the Supreme Court has been focused over the last few years quite a bit on Article 3 standing. So this may be an issue that they weigh in on again. Next slide, please. This case, Ryan was going to take this case. Go ahead, Ryan.
Oh, thank you, Ada. So
Sorry.
This matter is an Eighth Circuit matter that involves the curious situation of standing when a third-party administrator or TPA is no longer involved with the plan. And this matter found that a plan participant does in fact have standing to sue a health plan's former third-party administrator. And in this matter, Seyfarth was seeking to recover ERISA benefits, and the Eighth Circuit considered the standing requirement to to sue Seyfarth's self-funded health plan's former third-party administrator, the benefit plan administrators of Claire, and the court did in fact find that the plaintiff had standing to sue that former third-party administrator. The benefit plan administrators argued that the plaintiff lacked standing because the TPA was no longer the TPA for the plan, so Seyfarth's injury, the denial of benefits, was no longer redressable by the benefit plan administrators. And the BPA relied on a prior Eighth Circuit opinion, Hall versus LHACO Incorporated, where the court held that, similar to this, an ERISA participant's benefit claim was not redressable against a former TPA because it could no longer pay benefits or enforce the plan participant's rights under the plan. However, since Hall, the Supreme Court has made clear that claims processing rules and elements of a cause of action are distinct from limitations on subject matter jurisdiction. The court explained that the provision relied on in Hall did not implicate jurisdiction. Instead, Section 1132E expressly references jurisdiction and provides no jurisdictional limitation on who can be sued under Section 1132. That a participant might not be able to enforce a money judgment against a former TPA does not, in fact, mean that she lacks standing to sue that TPA, and thus the Eighth Circuit held that Seyfarth had standing. Thanks for letting me discuss that, Ada. I'll flip it back to you, and next slide.
Thank you. So the Windsor versus Sequoia benefits case, which you see on your screen now, is a Ninth Circuit decision. This one is much more in line with what the Supreme Court determined in the Thole case. Here, again, we have a situation where the plaintiffs are bringing claims for breaches of fiduciary duty, but they could not show any harm had resulted from the breaches that they were alleging. So just basic facts, this is a multiple employer welfare arrangement, so a MUA, and Sequoia here administered the MUA. And it also acted as a broker for insurance benefits that would be offered to the employers and their participants that participated in the MUA. In those transactions, it would receive, allegedly in the complaint, commissions and the like from those insurance companies. And the plaintiffs argued that that was a breach of fiduciary duty. The court said, well, you haven't shown us how getting rid of those commissions would in fact lower your contributions or have some other impact on your fees, and therefore this is too remote and you do not have Article 3 standing. Okay, and I'll turn it over to you, Ryan.
Thanks again. So we'll talk a little bit about administrative exhaustion, particularly a case out of the Eighth Circuit. Administrative exhaustion normally requires a participant in an ERISA plan to go through the plan's internal claims and appeals procedures before bringing suit to seek relief, judicial review of a denial. In Yates versus Metro Life Insurance Company, the Eighth Circuit held that administrative exhaustion was not required if the plan contains no claims procedures, which is a common sense opinion by this court. The Eighth Circuit considered whether an ERISA plan participant was required to exhaust, where the written plan document does in fact not provide for or describe any appeal review procedures. And in this matter, Yates sought accidental death benefits under an ERISA governed benefit plan sponsored by her deceased husband's former employer and insured by defendant Symetra. After Yates submitted a claim for accidental death benefits, her denial letter outlined an internal review process. However, the plan documents made no mention of this review process, nor did they describe any appeal procedures to follow after denial of benefits. Due to the lack of guidance with the plan, Yates did not appeal and instead brought suit where the court, in fact, granted the defendant's summary judgment motion on the basis that Yates did not exhaust administrative remedies prescribed in the denial letter. The court held that an ERISA plan participant was not required to exhaust administrative remedies before filing suit when the written plan documents were silent on any such administrative remedy discussion, despite the fact that a denial letter actually discussed an internal review procedure. The court held that the courts are to enforce the terms of the written plan documents, and certainly highlights the importance of ERISA plan document and underscores how exhaustion is not per se required by ERISA. All right, I'll go back to Jules and we'll talk about arbitration and venue selection.
Thanks, Ryan. As you've probably heard in the previous slides, there's some amount of variation between circuits, between jurisdictions as to what particular law governs a claim, ERISA claims. And one sort of instinctual approach that we've seen is that plans will say, well, can we try to short circuit some of these plan-wide claims, or short circuit a broader claim against the plan by arbitration? Or can we at least get out of court? And the answer is sort of. As you'll see on the slide here, the question of arbitration clauses and ERISA plans and whether they're enforceable has been percolating through the courts of appeals over probably the last 5-10 years. And I think there's a general consensus that arbitration clauses by themselves are valid. ERISA allows arbitration clauses, but that doesn't mean that every single arbitration clause is going to be enforced. For example, if an arbitration clause isn't actually wide enough to cover a claim for benefits, even if there is an arbitration clause, the court is going to look at it and say, well, that claim can't go to arbitration. It's not within the scope of the clause. Something else that has happened in the last couple of years has been litigation regarding whether plans can prohibit participants from bringing claims that affect other plan participants by limiting the arbitration to just a claim for individual benefits. This is somewhat analogous to cases that came up in the wage and hour context, where there were class action waivers in arbitration agreements, and courts often upheld those class action waivers. That has not necessarily been the case with ERISA. There are a couple cases that we'll talk about in a minute where courts of appeals have declined to enforce arbitration agreements that don't allow plaintiffs to pursue plan-wide relief. And to the extent that the arbitration provision is somehow invalid, if it's expressly not severable, or if the plan doesn't discuss severability, then the arbitration clause could fall entirely if it's overbroad. Next slide, please.
And I just want to jump in on that a little bit more, Jules. We've certainly had clients looking at arbitration, and there's a number of factors to be taken into account. The federal courts are very well versed in ERISA and its sort of unique features around discovery and looking at an administrative record and the discretion that's afforded to the plan administrator in determining that claim. However, as we've seen, these moves that are making it more and more difficult for a defendant to get dismissal on a claim that is purely frivolous, that is causing many of our clients to take another look at arbitration. So that is something that we're having many clients revisit because of these other developments in the class action sphere. Go ahead, Jules.
Thanks, Ada. One case that was recently in the news was Harrison versus Envision Management. The Supreme Court declined cert in the case about 2 weeks ago, and perpetuated something of a, I would say, somewhat lopsided circuit split on whether an individual arbitration clause in a plan document can cut off plan-wide or class litigation. So in Harrison, the plaintiff brought a sort of laundry list of your typical breach of fiduciary duty claims, and sought plan-wide relief, removing the plan trustee, restoring all losses resulting from the breaches, and disgorgement of profits. Obviously, all of those remedies aren't really enforceable on a single plaintiff basis, because those remedies impact other plan participants. If you order a fiduciary removed, as the court said, you can't order a fiduciary removed for just one participant. That has to be plan-wide. Similarly, if there are profits that come from a breach of fiduciary duty, then those profits have to be returned. The other plan participants are going to benefit from those profits being returned to the plan. The problem, though, is that the plan document in Harrison said that the arbitration was mandatory, but also couldn't cover any claims that would result in other relief to other plan participants. So there are two options there. Either the arbitration is limited to the plaintiff's particular claims, or the arbitration clause is invalid. And in this case, the 10th Circuit said, well, that's invalid. The relief that the plaintiff was seeking was statutorily authorized by ERISA Section 409, again, 29 U.S.C. 1109, for those who are keeping the chart at home. And they said that the Court of Appeals said that that even though a plan can have an arbitration agreement, it can't prevent plan participants from effectively vindicating statutory rights under ERISA. If this same arbitration agreement had come up in the context of an individual claim for benefits, there's a pretty good chance it would have been enforced, because it wouldn't prevent the participant from getting the benefits sought. But in the breach of fiduciary duty context, where participants seek plan-wide relief, the Court of Appeals said that you can't limit participants to remedies that don't cover the extent of remedies offered by ERISA. And there was a similar case in the Third Circuit, also decided this year, where the arbitration provision in the agreement prohibited any lawsuit that seeks or receives any remedy that has the purpose or effect of providing additional benefits or monetary or other relief to any third party. Like in Harrison, the plaintiff there had brought a variety of claims seeking plan-wide remedies. And the Third Circuit, like the 10th Circuit, said that the plan cannot prohibit a participant from seeking those statutory remedies just through an arbitration agreement. One sort of side point is that both Harrison and Henry talk about fiduciary breach claims as being brought in a representative context on behalf of the plan or on behalf of plan participants. And that language, further to what Ada was saying before about Article 3 standing, and that language about representative or on behalf of the plan, other courts have latched onto in the standing context to allow participants a little more leeway in bringing claims, even if they personally weren't involved in or if they personally weren't invested in some of the investments that are being challenged. So it'll be interesting to see how these two areas, which are in a lot of ways very different, but both focus on the representative status of the plaintiff representing the plan, how they interact with each other and kind of feedback on each other. Next slide, please. And one other thing to keep in mind if you're considering an arbitration agreement is that arbitration clauses are not entirely without risk. Even if the court puts a case in arbitration, the arbitrator may or may not be as familiar with ERISA as a federal court. There's very limited review of an arbitrator's decision if they get it wrong. And unlike a sort of run-of-the-mill ERISA case where you're guaranteed to be in federal court, if you were to challenge an arbitrator's decision, there's a recent Supreme Court case from last year, Badgerow versus Walters, that said if there's no underlying jurisdiction to hear a case attacking an arbitrator's award, that goes to state court. So even if the plan were to have an arbitration agreement and it were to be enforced, any attempt to enforce the arbitrator's decision or to challenge the arbitrator could end up with an ERISA plan litigating in state court, which might be something of a drawback. So not necessarily saying that this shouldn't be done, but it's certainly something that to keep in mind when considering issues with plan arbitration clauses. Next slide, please. And one additional item to touch on very briefly is that in addition to arbitration, another attempt to sort of get into a better forum is a forum selection provision in plans. Courts have typically allowed plans to enforce a forum selection provision. Not all the courts of appeals have weighed in. The ones that have allowed them, and it provided that the plan designates a forum that's permissible under ERISA, and that's a tool that might be used to steer cases to a single forum, which would allow that court's judges to be familiar with a particular plan and might also be helpful in steering cases to a place where case law might be somewhat more favorable. One example of this, which Ada is going to talk about momentarily, is the question of jury trial rights in breach of fiduciary duty cases. Most courts hold that there is no such right, but in the Second Circuit, there is case law, and there recently was, in fact, a jury trial in the Second Circuit in an ERISA breach of fiduciary duty case. The Second Circuit has law that certain courts have interpreted to allow a jury trial if participants seek make whole relief against a fiduciary. So even if the vast majority of the remedies sought are equitable and don't get a jury trial right, if you're in the Second Circuit, there's a higher risk than elsewhere that a fiduciary breach claim might be in front of a jury, even if that seems to somewhat conflict or clash with Cigna versus Amara, that claims against fiduciaries are equitable claims for equitable relief. Ada?
Thank you. So as Jules was talking about, we're seeing the emergence of more discussion, more jury demands that are surviving motions to strike and that sort of thing. And in fact, even jury trials going forward in ERISA matters, which is somewhat unheard of. It seems like from my practice, every 10 years, there's sort of a flare up in this area. And then in the meantime, it seems very well settled based on the court's, for example, Amara Supreme Court decision, which says even if you're getting money in some form, it's still being awarded as it would be in a court of equity and is fundamentally an equitable right. Therefore, there's no right to jury trial. As Jules was talking about, we're seeing some different analysis around that, including in the Second Circuit, we're starting to see a few cases that have allowed jury trials. So we'll talk next slide, please, about one of those cases. So as noted, there was a class action 401k fee case that was tried to a jury in the spring. It was an interesting mixed bag in terms of the verdict, but at the same time, I think there's a real danger of participants, and apologies if you can hear noise outside my window. There's a real concern from a defense perspective about a jury sort of second guessing the investment decisions of an investment advisor, an independent investment advisor, a committee that's fully informed and looking at the information. So that this is a I would say troubling development from a defense perspective. The first case there, we're also seeing some interesting things where you've got jury, non-jury claims. So that is claims that are considered equitable and claims that are considered legal. So this Carries versus Southern Pines case involved a retaliation case under ERISA under Section 510, and then other sort of wrongful termination claims where the plaintiff was entitled to a jury. In that instance, the judge said, I'm going to take the jury's decision on the 510 claim as an advisory decision and nothing more. At the conclusion of the trial, the judge overruled the jury's finding, which was in favor of defendant, and ruled for plaintiff, finding that the plaintiff had established by a preponderance of evidence that there was retaliation. This went up on appeal, and the defendant said, wait a minute, this was supposed to be an advisory opinion only. The Third Circuit went back to some law outside of ERISA, really, which was talking about when you have an intertwined equitable and legal claim, and said the right to jury trial has to be preserved by accepting the jury's findings on common facts for all purposes. And what that means is that even if you have an advisory jury, if they made implicit or explicit findings of fact, those have to be considered by the judge in making a ruling on the non-jury claim. And the Third Circuit found that in this instance, the judge had decided appropriately and affirmed the judge's decision. If the next slide, please. And we'll just jump through this so we can make sure we hit some other topics for you as well. Just beware that jury trials are raising their heads in these cases, that the motions to strike are taking, it used to be pretty standard that the judge accepted that all of the remedies sought are equitable and that there's no question about the jury trial. That is no longer the case. So it makes sense to discover which circuit you're in, and even judges within circuits have varied in their conclusions. So that's also something to pay attention to. And with that, I will read the CLE code, which is Seyfarth, SS 5747. So SS as in Seyfarth Shaw 5747. With that, I'll turn it over to Ryan.
Thank you, Ada. Our final topic today is ERISA Health and Welfare Plan litigation. And next slide, please. And for this topic, I'll first discuss a couple-minute digest of the procedurally complicated matter of Witt versus United Behavioral Health, which had additional updates this year. Starting on March 22nd, 2022, the Ninth Circuit issued an unpublished memorandum, and after the plaintiffs filed a petition for rehearing with amicus support, on January 26, 2023, the Ninth Circuit issued a published opinion, which was recently vacated and superseded on August 22nd of this year. At that time, the Ninth Circuit panel granted the plaintiff's motion for panel rehearing and vacated and replaced the January 26, 2023 opinion. The most recent August 2023 Witt opinion, the Ninth Circuit remanded the matter to the district court to determine whether the exhaustion requirement applies the fiduciary breach claim under Section 502(a)(3), and if so, whether the requirement was satisfied by the unnamed class members or should be excused. Next slide, please. The court noted that exhaustion is not required for statutory breach of fiduciary duty claims, but it is required if the statutory claim is a disguised claim for benefits. So the district court did not ultimately decide that issue, but held that the class members were excused from exhausting their claims because the named plaintiffs exhausted their remedies. And supposedly this put United on notice of the class members' facial challenges and arguments. The Ninth Circuit rejected that and remanded the matter to the district court to decide that issue and to determine whether plaintiff's breach of fiduciary duty claim was a disguised claim for benefits subject to the exhaustion requirement. So this matter is a bit of a wait and see. This is already the third time that we've had an opinion here of this long and complicated matter. And the most recent opinion by the court seems to have taken a lot of wind out of the sails of the prior January opinion, but it remains to be seen what happens, and we'll keep a close eye on this one. And in the last minute, I'll talk briefly about the Mental Health Parity Act and part of the health and welfare litigation. Next slide, please. So under the Mental Health Parity Act, ERISA requires that most plans provide equivalent benefits for mental health as those provided for medical and surgical care. And recently, the White House put new regulations out to ensure plans compliance with the Mental Health Parity Act and put further proposed regulations. And those regulations would amend existing regulations under the Act and would add additional requirements for group health plans and insurers that apply non-quantitative treatment limitations to mental health and substance use disorder benefits. Next slide, please. And finally, the new proposed regulations expand on how to comply with these content requirements to highlight types of required data, records, certifications, and documentation that must be presented. And we would encourage you to visit us or contact us for more information about this as I reach the end here with not much time. But I'll send it over to Ada and Jules for our concluding remarks. And thanks everyone for your attention today.
Thanks, Ryan. So we'll leave you with this, and we do have a webinar focused exclusively on this subject coming up in the next few weeks, so look for an email invitation to that. But what we wanted to make sure everyone is paying attention to is we are seeing the plaintiff's bar that's been bringing the 401k and 403b fee litigation cases turning to health and welfare plans. They're focused on a formal amendment to 408b2, which required more disclosures by health and welfare plan service providers to plan fiduciaries. And we expect they're going to be making very similar claims as we see in the 401k fee litigation context. So it's an opportunity now to take a look at the arrangements you have there, the fees, and those sorts of things, with the recommendation that you do it in conjunction with your counsel for privilege reasons. But we do expect a wave of that litigation to start shortly. And thank you all for attending.
Thank you, everyone.